The one point
we may not have to reach the constitutional question. That's what constitutional avoidance hopes for.
Right, but I don't see any argument on the other side that's really a constitutional avoidance argument. Their principal argument is
the argument the other side, if you want the argument the other side, is there are several hundred cases already pending. And therefore, if we accept your interpretation, we know we have to reach the constitutional argument. If we reject your interpretation, since all these cases, several hundred of them, are already there, it might be new ones won't be brought. But of course new ones might. And therefore, what is your answer to the question that this is unconstitutional, if not here, in other places?
And Justice Breyer, what I would say is that our interpretation basically provides for pending claims exactly the way that Congress did. With respect to any future claims that might be brought, there may or may not be a constitutional question. And if I could turn to our interpretation of the DTA, it's the only one that really, I think, reads the various provisions in the statute in harmony. Now, this Court's decision in Bruner and in a host of other cases says that when Congress eliminates jurisdiction, pending cases fall unless there's a savings clause. The closest thing to a savings clause in this statute in E1 is the provision that says, except pursuant to Section 1005. And I think that's important because if Congress wanted to put in a savings clause of the kind that this Court seems to refer to in Bruner, and that would certainly be consistent with Senator Levin's intent, it would have been very easy. Instead of saying except for Section 1005, they could have said except for pending cases. The choice is important because what does Section 1005 provide? It provides the exclusive review in E2 and E3. And then H2, in very complementary fashion, says that just in case there's any question about it, those provisions on E2 and E3 apply to pending claims governed by those sections. I think every word's important. It doesn't say pending cases. It says pending claims. Congress understood two important things. There were no cases currently pending under E2 and E3 because Congress was creating E2 and E3. It also knew that most of the cases before the D.C. courts had some claims that were pure challenges to the final CSRT determination and other claims. So what H2 says is H2 says that to the extent those cases involve claims governed by E2 and E3, they are preserved under E2 and E3. Otherwise, there's no savings clause that covers those claims, and their jurisdiction is removed. The retroactivity aspect, I'm sorry.
May I just ask this, just clarify. When they do take away some jurisdiction of some habeas corpus claims, do you defend that in part as a permissible exercise of the power to suspend the writ, or do you say it is not a suspension of the writ?
I think both, ultimately. I mean, I don't think...
It can't be both.
Well, I don't see why I can't have alternative arguments here as where anywhere else, Justice Stevens. We think that Congress, in this action, did not do anything that triggers a suspension of the writ. But if you think that it did, I think...
That's your position. They did not suspend the writ. You're not arguing that it's a justifiable suspension of the writ.
Well, I think that the terms of the suspension clause would be satisfied here because of the exigencies of 9/11. If the question is, am I taking the position that Congress consciously thought that it was suspending the writ, then I would say no. And if you think in order for there to be a valid suspension, Congress has to do it consciously, then I think you could see why the arguments are mutually exclusive. My view would be that if Congress sort of stumbles upon a suspension of the writ, but the preconditions are satisfied, that would still be constitutionally valid. So I think that may be the disagreement.
Isn't there a pretty good argument that a suspension of the writ of Congress is just about the most stupendously significant act that the Congress of the United States can take, and therefore we ought to be at least a little slow to accept your argument that it can be done from pure inadvertence?
Well, a couple of things, Justice Souter. I would agree with you if what we were talking about is suspending the right as to citizens within the continental United States. But all Congress did here is restore the law to the understanding of the law that had prevailed for 200 years. Now, this Court obviously took a bit different view in Rasool.
If we have to get to the issue, in accordance with Justice Breyer's question, whether or not the writ of habeas corpus was suspended, you are leaving us with the position of the United States that the Congress may validly suspend it inadvertently. Is that really your position?
I think at least if you're talking about the extension of the writ to enemy combatants held outside the territory of the United States.
Now, wait a minute. The writ is the writ. There are not two writs of habeas corpus for some cases and for other cases. the rights that may be asserted, the rights that may be vindicated will vary with the circumstances, but jurisdiction over habeas corpus is jurisdiction over habeas corpus. And it seems to me that the position you have taken is that if at the end of the day we have to reach the question that Justice Breyer described, the answer to that question may be, yes, the writ of habeas corpus was suspended by inadvertence. Congress did not intend to do it. Is that really your position?
No, Justice Souter. My point is not inadvertence. It's whether they have to say or incant any magic words that they are now invoking their power to
surely set forth a procedure which amounts to a suspension of the writ. And if that procedure in a state of insurrection or invasion, that would constitute a suspension of the writ, even though they don't say we are suspending the writ of habeas corpus.
That is my point, and there's nothing inadvertent
Is it
here.
also your point when there is no insurrection or invasion?
Well, then any effort to suspend the writ would be invalid. But this is not a case where there's any question of
Perhaps that's something that a court ought to inquire into when it gets into the question of congressional intent.
I don't think I disagree with that. I guess my point
and how specific that intent must be.
I don't think I disagree with that, but there's two separate points here. One is, does Congress have to say we are now suspending the writ under our suspension clause? And I don't think there's any call to say that they have to do that. Obviously, in cases like St. Cyr, this Court has been very clear to say Congress obviously can't stumble upon the habeas clause.
Okay,
that's not an issue
let's
here.
assume we do not have a magic words requirement. Given the significance of suspending the writ of habeas corpus, should we not have a pretty clear statement requirement?
Yes, and there's no question that Congress here tried to amend the habeas statute. This is not like St. Cyr, where they didn't go after 2241 in terms. There's nothing subtle about this statute with respect to the clarity with which it speaks.
There may be nothing subtle about the statute, but there is something very silent about the statute as to whether Congress understood that it was acting under its authority to suspend the writ of habeas corpus. And at the very least, that unclarity is manifested by the effective date provision. H1 doesn't have the language that it had before the amendment. Therefore, it seems to me there would be some difficulty if we have to get to the question in finding a clear intent on the part of Congress to suspend the writ under its Article I power.
With respect, Justice Souter, I don't think making a retroactivity analysis or holding here is going to spare you the trouble of dealing with the suspension clause argument. I mean, in St. Cyr, it's worth noting that this Court addressed the specificity with which the statute applied separately from the retroactivity question. Here, to take the first question first, there's no question this wolf comes as a wolf. Congress was going after 2241. It clearly did that. All of E1 is a new subsection to...
It comes as a wolf under H2, but the wolf is silent under H1, and the wolf used to speak under H1, and it had its teeth taken out.
With respect, Justice Souter, H1 never spoke to the question. An earlier provision, D1, had very different language than an earlier provision of the statute that spoke with greater clarity. I'll grant you that.
That's gone.
That's gone. But just because Congress could have made it clear doesn't mean that the government loses here.
The very fact that Congress chose to remove the clarity of the prior provision is of no significance?
It's not of dispositive significance, Justice Souter.
I don't think Congress chose to do that. One house of Congress chose to do it. We don't know what the other house thought, and we don't know what the president thought.
That's a very fair point, Justice Scalia, but even to get at what happened here, it's very analogous to the legislative evolution this Court found unilluminating in Martin against Haddix. There, the attorney's fees provision you had before you used to be in 802 of the statute, which was expressly applicable to pending cases. Congress moved it out into its own separate section that didn't expressly apply to pending cases.
Whatever may be the standard of due care for courts in reviewing acts of Congress with respect to attorney's fees, it doesn't reach the level that it seems to me is incumbent on us when we're talking about suspending the writ of habeas corpus.
I don't disagree with that, Justice Souter, but there's no special habeas retroactivity law. There is a special rule under St. Cyr for habeas, but we amply satisfy that because this whole thing is a 2241E new section. So this is all about amending habeas.